ADR-LINK is a program of the London Family Court Clinic and matches families referred for service to qualified ADR practitioners. The practitioners are not LFCC employees and do not work for Children's Aid Society offices. They are independent, impartial professionals trained to assist families and CAS to work towards resolutions that will focus on the best interests of the child or children.
As we forge forward and continue working with Indigenous nations, we want to first acknowledge, respect, and recognize the deep connection and historical relationship Indigenous peoples and the land we share. With support, accountability, and much respect to the following traditional homelands and territories of the Anishinaabe, Ojibwe or Chippewa Nation, Haudenosaunee, people of the Iroquois, which includes the United Nations, Lenape, also known as the Delaware, and the Attawandaron, also known as the Neutral, the Wyandot, also known as the Huron. There are 11 First Nation communities in the region of southwestern Ontario and over 120 First Nations in all of Ontario.
Alternative Dispute Resolution, most often referred to by its acronym of ADR, came into being in 2006 when the Child and Family Services Act, as it was then called, was amended to stipulate that Children's Aid Societies must consider ADR for children who are or who may be in need of protection. There are three main prescribed methods of ADR: child protection mediation, family group conferencing, and original dispute resolution, which is sometimes called Indigenous approaches to ADR. There is a Ministry Directive, CW-005-06, which outlines the three prescribed methods of ADR, as well as a fourth option that can be community-specific and is approved by the Executive Director of a Children's Aid Society. The directive outlines the qualifications and criteria for ADR facilitators, including criteria for neutrality, use of a written agreement including confidentiality provisions, and the conditions under which the CAS must provide notice to the Office of the Children's Lawyer. Referring workers from Children's Aid Societies, band representatives, FNMI communities, or any other party can request ADR services for families, either prior to court involvement or during court involvement. A judge may also request that the involved parties consider participating in a prescribed method of ADR. All ADR services in Ontario are completely voluntary, and participants can elect to not participate in an ADR service. In the West region, ADR-LINK is funded by the Ministry of Children, Community and Social Services, also known as the MCCSS, and housed at the London Family Court Clinic. ADR-LINK has the responsibility to manage referrals and match the referral to an ADR practitioner. For more information on how to make a referral, please view the video on ADR admin and how to make a referral. Let's look at an overview of child protection mediation. The Ontario Child Protection Mediation roster is managed by the Ontario Association for Family Mediation, commonly referred to as OAFM. OAFM ensures all rostered child protection mediators meet the minimum requirements set out by the Ministry, such as carrying liability insurance, having a vulnerable sector check completed every 3 years, and conducting themselves appropriately as mediators with special training in child protection mediation. All child protection mediators' names and contact information can be found on the website www.cpmed.ca. There can be many participants in a child protection mediation. Firstly, and most importantly, the main caregivers of the children, whether that be the parents, extended family members, kin caregivers, or foster parents, voluntarily consent to participate in the mediation process. The Office of the Children's Lawyer assigns legal counsel for the child in some cases. Most often, child's counsel will attend the mediation on behalf of the child to bring the child's views and preferences into the discussion. If the mediation is regarding a youth, then the youth often participate in the mediation directly, accompanied by their OCL. The staff and legal counsel of the Children's Aid Society also participate in the mediation. There may be several CAS staff depending on the issues to be discussed. CAS staff are there to support families and hear firsthand of the plan for the child or children. Afterwards, their job is to support the implementation of the plan, so it is important that they understand the plan and the reasons behind it. The party's legal counsel also often participates in the mediation. Typically, if one lawyer attends, all parties' lawyers attend. And lastly, but a very important role, is the service provider for any adults who require extra support during the mediation to help ensure that the adult understands the proceedings. For example, this may be a translator, an adult developmental support worker, a Canadian mental health worker, or a service provider from various agencies. A child protection mediator will meet with all parties individually, including the referring worker and manager from the Children's Aid Society and the child's counsel, before bringing everyone together for the mediation. The mediator will explain the process, ensure that the parties understand the voluntary nature of their participation, and the confidentiality provisions in place for the mediation. If the party agrees to participate in the mediation, the participant has an opportunity to provide background information to the mediator relevant to the mediation, as well as identify their hopes for the final agreement. The mediator will screen for imbalance and design a process to allow all participants to partake in the mediation in a safe and healthy manner. The mediation itself can be either in person or virtual, depending on the needs of the participants. The participants may choose to have their legal counsel present. If OCL has assigned legal counsel to the child, then they are almost always present at the mediation. The mediator often starts the meeting by reviewing the agreement to mediate and setting the agenda. You can expect that the mediator will facilitate a discussion amongst the participants by paying careful attention so that all voices are heard and respected. Typically, this is a 2 to 3 hour meeting, and there may be additional sessions if required. Families and Children's Aid Societies sometimes return at a later date to mediation to ensure that the plan they developed stays on track. But this is something each family decides in conjunction with the Children's Aid Society and mediator. At the end of mediation, if full or partial agreement is reached, then the mediator will write up a mediator's report and send this to all participants and their legal counsel. The report itself is not legally binding, and all parties are advised to seek independent legal advice on the mediated agreement and how to make the terms of the agreement binding if desired. Why use child protection mediation? Child protection mediation is part of a larger array of alternative services offered to families. Some of these services are conducted by someone who works for a Children's Aid Society, such as Sign of Safety, and sometimes they are conducted by someone who does not work for Children's Aid Society, such as child protection mediation. Using both internal and external facilitators can be very helpful in moving the work with families forward. It allows for empowerment of families and respects families' ability to be their own decision makers, and supports families in knowing what is best for their child or children. Child protection mediation can often be used in conjunction with other services offered to families. For example, at a Signs of Safety meeting, it may be decided that a child protection mediation is required to negotiate the terms of an openness agreement. So, a referral for ADR is then made and the mediator conducts a child protection mediation. Similarly, the initial plan may be created for a youth in a family group conference process. Then the Children's Aid Society continues to monitor the plan by using child protection mediation sessions. Child protection mediation is a common alternative for courts to allow families to have agency over their lives in creating plans for their children. Child protection mediations are often used to discuss openness agreements for children so that they can continue to know their birth families to some degree when they are being adopted. Child protection mediations are also often used to create parenting plans or review existing parenting plans when there is a lot of conflict between the parents post-separation or divorce. Another way in which child protection mediations are used is in the development of a plan to return children to the care outlined in said plan, and monitoring of that plan over time. This is generally done by meeting every few months to modify the plan to ensure that it continues to meet the needs of the family. There are many reasons why using child protection mediation makes good sense for families and good sense for the referring agency. Child protection mediation nurtures creative resolutions that work for families. Empowered families are more capable of working with professionals to identify the issues and collaborate to come up with creative solutions through comprehensive information sharing. The child protection mediator uses a variety of techniques to help the participants communicate with each other, tell their stories, identify the issues and concerns, and eventually craft agreements that are viable. A mediated agreement needs to be able to stand the test of time and continue to work for families long after the Children's Aid Society has concluded their involvement. What's the role of the referring worker in child protection mediation? The referring worker will share initial information with the mediator, with permission of the family. Understanding families' relevant involvement with the Children's Aid Society and understanding the issues that need to be mediated are critical in designing a child protection mediation process that will be successful. The referring worker may be called upon if the child protection mediator is having difficulty getting in touch with the participant. So often, phone numbers or emails have been updated, and having the most current contact information is vital. At the mediation itself, the referring worker attends, most often with their manager or supervisor. The referring worker will express the views of the Children's Aid Society in a transparent manner, so all participants are aware of the position of the Children's Aid Society. This is usually a short statement, but the referring worker should be prepared to speak. During the mediation, the Children's Aid Society staff do not take notes. It is the mediator's notes that will form the basis of the mediator's report if partial or full agreement is reached in principle. The OCL and legal counsel will often take notes, as their notes are privileged. After confirming the family is willing to participate in an ADR service and consents to their information being shared with ADR-LINK and the ADR practitioner, complete the ADR referral form and provide as much detail as possible. Send the completed Office of the Children's Lawyer notification to the Office of the Children's Lawyer via fax to 416-314-8050 or email ocllegaldocuments@ontario.ca. Send the completed ADR referral form, all signed consents, the Office of the Children's Lawyer notification form, and proof that it has been faxed to the Office of the Children's Lawyer, to ADR-LINK@lfcc.on.ca, or fax the documents to 519-679-4234. For further information about child protection mediation, please consult the ADR-LINK website, www.adr-link.ca, or the Child Protection Mediation website, www.cpmed.ca.